Good afternoon, everyone. This is Eve Green Cooper-Smith from Garfunkel Wild, and we're going to begin this afternoon's webinar entitled Revisiting DNR, DNI, and Other End-of-Life Issues. We're going to start with patients with decisional capacity. Do you know your patient's wishes? That's going to be the first question you always ask in these kinds of matters. Decisions that are made by an adult patient with capacity must be honored. The law provides that every adult with decisional capacity has the right to consent to or refuse medical treatment, even if that decision will result in the patient's death. The right that each individual has to make decisions regarding their medical care is considered a liberty interest, which is protected by the due process clauses of the New York State and United States Constitution, and we hold this liberty interest to be sacrosanct. Advanced directives, which you've all heard about, they can be oral or written. Most often, it's a written document that typically sets forth the patient's instructions regarding his or her medical treatment under certain specified circumstances. An advanced directive also can appoint a decision maker. Examples of advanced directives include a living will, a healthcare proxy. In other states, it might be called a designation of a healthcare power of attorney. A do not resuscitate order is considered an advanced directive, and a MOLST form. MOLST stands for Medical Orders for Life-Sustaining Treatment, and we will talk about that in this webinar. Healthcare providers and healthcare practitioners are obligated to disseminate information about a patient's right to execute advanced directives. Every patient admitted to a hospital receives a packet of information, and in that packet is the New York State information form and form itself for the making of a healthcare proxy. As we talked about before, a living will is an advanced directive, and it is a document that is signed by an adult person with decisional capacity that contains his or her instructions about treatment to be followed if he or she becomes incapable of making treatment decisions directly. So it's a document that applies in the future. It's my statement of my wishes now to be applied in the future if I cannot speak for myself. A MOLST is a bright pink medical order form that summarizes a patient's wishes regarding various life-sustaining treatments. It might include a do not resuscitate order, that's on the first page of the form. It might include do not intubate. It can provide instructions for feeding tubes and artificial hydration through an IV tube. It can provide for an instruction about future hospitalization and a patient who may not want to be hospitalized. And it can also specify specifically whether the person wants antibiotics or does not. The MOLST form is available in electronic form as well. There is an electronic eMOLST registry throughout New York State. The MOLST form is completed by the patient's attending physician. It does serve as physician orders. And it's made after consultation with the patient, a healthcare agent, or a surrogate decision maker, depending on whether the patient does or does not have capacity. What's the difference between a non-hospital DNR and a MOLST form? As I said before, the MOLST form is a hot pink form and in color, and it's done that way so that it stands out. It is intended to be utilized in any patient care setting and across all patient care settings and the healthcare system. So it can be followed, it can be used in a hospital setting, in a nursing home setting, at home, in the community as well. And all first responders, hospital emergency rooms, emergency medical services, are obligated to follow the physician orders that are stated in the MOLST form. So once a MOLST form is made, it stays with the patient. Unlike a hospital DNR, where you make the DNR in the hospital and then that form stays at the hospital, it doesn't follow the patient unless you make a non-hospital order not to resuscitate. The DNR stays at the hospital. Outside the hospital, you need a non-hospital order not to resuscitate. And on this slide, you'll notice that I provide to you the actual form that the Department of Health requires. If you have a non-hospital order not to resuscitate, you must use the DOH form 3474. And this is valid in out-of-hospital settings. So it only applies in a community setting, in somebody's home. When somebody gets a non-hospital order not to resuscitate, they often will post it on their refrigerator so that if EMS is called, it can be easily viewed by EMS and can be honored. And a DNR only applies to cardiopulmonary arrest. It does not apply to any other form of treatment. You can have a DNR and still have all other forms of treatment provided to that patient. What's the difference between a living will and a DNR or MOLST form? A living will, as we said before, sets forth the patient's instructions to apply in the future when the patient is unable to speak for him or herself. A DNR and a MOLST form are actual physician orders that are based upon the patient's current wishes, so they apply immediately. Advanced directives must be honored by healthcare providers and healthcare practitioners. When an advanced directive has been presented to a healthcare provider, a copy of the directive must be placed in the patient's medical record. So if you receive a copy of a healthcare proxy signed by the patient, it must be included in the patient's medical record. Same would be true for a MOLST form. A copy of the MOLST form would have to be put in the patient's medical record. Whether a healthcare provider must honor the advanced directive does depend on the type of advanced directive it is and the patient care setting. And so let's talk a little bit about that. A DNR, a non-hospital DNR on the proper form, and a MOLST form are the type of advanced directives that must be followed and are effective immediately because these are physician orders. A healthcare proxy and a living will require a physician's determination of incapacity. So while you will be looking to those documents, you must first take some other steps. Let's talk about the effect of a living will. A living will does not appear anywhere in the law. There's no legal statute or regulation that talks about how to make a living will. But through case law and through other statutes, we know that a living will can be legally binding and provide clear and convincing evidence of a patient's wishes to forego life-sustaining treatment. The patient's wishes, as expressed in a living will, can be honored if the instructions are clear and address the very circumstances in which the patient is now found. So, for example, if a patient says in their living will that they did not want cardiopulmonary resuscitation, and that they would have wanted a DNR order in the event that they had an incurable medical condition which was irreversible and was compromising their ability to engage with their environment, something very specific with respect to what treatment they wanted and the medical condition that they're in now, you could honor that living will and follow the instructions given by the patient. Good faith reliance on a living will presumes that the physician has no reason to believe that the living will was revoked by the patient or that the patient gave any contrary instructions. There are times that you might be presented with a living will and a family member who comes forward and says, no, that's not really what mom wanted, not in this time, not she changed her mind or she gave some further instructions that are different. A physician or a healthcare provider may choose not to honor a living will if provided with that type of reliable evidence that shows that the living will was signed perhaps due to fraud or duress or coercion, that the patient did not know what he or she was signing, that the patient subsequently revoked the living will or expressed a change of intent. That's what we were talking about a moment ago. Or if the living will is vague and there is disagreement among the family members or others regarding its interpretation and the proposed application. And that tends to happen, of all of these items on this slide, that tends to happen the most, where the living will was created by an attorney or perhaps something that the person got off the internet, and it's very vague. And in those situations, if there's disagreement among family members, the healthcare provider can seek further clarification. What is the role of a living will when the patient also signed a healthcare proxy? Well, the living will provides guidance and limitations regarding a healthcare agent's decision-making authority. And the reason I'm saying that is because the law requires that a healthcare agent make decisions consistent with the patient's wishes and instructions. And those instructions can be set forth either on the healthcare proxy form itself or in a living will. So the living will, as I said a moment ago, does provide guidance and in some cases can actually limit the decisions that can be made by a healthcare agent. Let's talk about the laws in general that govern decision-making for an incapacitated patient. The first consideration is always capacity. There's a definition of the term capacity, which I've included on this slide. We're up to slide 15. Capacity is defined as the ability to understand and appreciate the nature and consequences of proposed health care, including the benefits and risk of and alternatives to proposed health care, and to reach an informed decision, a decision in which they are weighing the risks and benefits to make a determination. Every adult patient under the law is presumed to have capacity to make healthcare decisions unless otherwise determined by a physician or a court order. Now, note that capacity does not mean that the person is free from all mental impairment. I know that many of the people on this webinar are social workers in a psychiatric unit. And we know from those patients, we have lots of patients who do not have any capacity with respect to making decisions about their mental illness, and they may deny that they have a mental illness, but they know that they have certain other chronic medical conditions, and they're absolutely willing to comply with treatment for those conditions. That's a classic presentation that happens on psychiatric units. So just because a patient has a mental illness does not automatically mean that they do not have capacity to make decisions concerning treatment of all of their conditions. A determination of capacity must be made by the patient's attending physician. The standard is that it must be made to a reasonable degree of medical certainty. Again, by the patient's attending physician and documented in the patient's medical record. The determination must state the cause, extent, and probable duration of the patient's incapacity, and the likelihood that the patient might regain capacity. So perhaps you have a person who was in a terrible car accident, and they don't have capacity at this moment in time because they're in a medically induced coma. there's certainly a hope and expectation that the patient's medical condition will improve and they will be able to be taken out of that medically induced coma and might regain their ability to make their own healthcare decisions. If a decision is going to be made regarding the withdrawal of life-sustaining treatment or the withholding of life-sustaining treatment, then another physician must examine the patient and confirm the determination of incapacity. So there's a requirement in all of the laws that apply that there be a concurrence of incapacity before a decision can be made to withhold or withdraw life-sustaining treatment. And this is true under the Healthcare Proxy Law and under the Family Healthcare Decisions Act as well. If incapacity is due to a mental disability, then there has to be a concurring determination of incapacity by an appropriately qualified physician. So if incapacity is due to mental illness, then there must be either the attending physician or a concurring determination must be made by a psychiatrist. If the incapacity determination is because the patient is developmentally disabled, has a mental retardation or autism or one of those types of mental disabilities, then the concurring determination must be made by a specially qualified physician or psychologist. And there are certain requirements that must be met for them to be considered specially qualified. Once a determination of incapacity is made, notice of that incapacity determination must be provided to certain individuals. Notice must be provided to the patient, orally and in writing if the patient is able to comprehend, to the healthcare agent if one has been appointed. If the patient is on a medical surgical floor of the hospital and they were transferred from a mental hygiene facility like the psychiatric unit, then the facility director of that mental hygiene facility must receive notice. Any conservator or committee appointed for the patient. And if there's no healthcare agent, notice must be given to the person on the surrogate list in the class highest in order of priority under the Family Healthcare Decisions Act. Now, if a patient objects to the determination of incapacity, a court order is going to be required. A judicial determination must be obtained in that instance, because the courts in New York take the view, and the law of New York is that the court is the ultimate arbiter of whether or not a person has capacity to make decisions for him or herself with respect to medical care. So the next step in decision making for persons who do not have capacity is to identify the decision maker. On slide 22, we list all of the types of individuals who can make decisions for an incapacitated patient. The first is a healthcare agent, if the patient has signed a healthcare proxy. If there's no healthcare agent, a surrogate who is identified under the Family Healthcare Decisions Act. If there's no healthcare agent or surrogate, certain healthcare providers can make healthcare decisions for an incapacitated patient, again, pursuant to and subject to the limitations of the Family Healthcare Decisions Act. A court can make those decisions. And if a patient is developmentally disabled or mentally retarded, there are special laws that apply that permit actively involved family members in an order of a list of priority to make major medical decisions. And in the absence of family, the surrogate decision-making committee or a court can also make that decision. There is a special process and law that applies to do not resuscitate orders and decisions to withhold or withdraw life-sustaining treatment. And that is found in the Surrogate Court Procedure Act 1750B. I mention that because if you're ever in a situation where someone is looking to make a decision for a DNR or to withhold or withdraw life-sustaining treatment for a developmentally disabled person, you're going to hear the phrase 1750B. That statute sets forth a process and a procedure as well as the criteria that must be followed when making that kind of decision. So moving on to healthcare agent. If the patient has a healthcare agent, the agent can make any and all decisions that the patient could make. The agent stands in the shoes of the patient. Healthcare decisions by a healthcare agent have priority over decisions by any other person except the patient. So when there is a healthcare agent appointed and mom appointed daughter number 1, and daughter number 3 comes up and says, daughter number 1 doesn't know what she's talking about. She's making terrible decisions. We would turn to daughter number 3 and say, I'm sorry, but daughter number 1 is appointed as the healthcare agent. And as long as we do not believe that the decisions are being made in bad faith or they appear to be consistent with any instructions that are given by the patient, or if there are no instructions, certainly appropriate decisions under those circumstances, then we're going to follow daughter number 1. Physicians and healthcare providers are obligated to comply with the healthcare decisions made in good faith under a healthcare proxy to the same extent as if they were made by the patient. And that language in this slide is really taken right from the healthcare proxy law. If there's no healthcare agent, then we identify a surrogate under the Family Healthcare Decisions Act, and we look to the surrogate list. And here is the surrogate list in order of priority. A court-appointed guardian appointed by the courts under Article 81 and authorized specifically to make major medical decisions. I mention that because there are lots of guardians who get appointed by the court under Article 81, but they are not given the authority to make major medical decisions. Sometimes, particularly if it's a case that involved adult protective services, and if an agency was appointed, sometimes the guardian is directed to encourage a patient to comply with treatment, assist the patient in making appointments. That's not the same thing as having the authority to make major medical decisions. So whenever you get a guardianship case, ask the guardian to provide a copy of the court order that lists their powers and look specifically for the power to make major medical decisions. And in that case, they would be the first in order of priority as a surrogate. Next on the list is a spouse or domestic partner, then adult son or daughter, then parent, sibling, and close friend in that order. And you'll notice that there's no order of priority among the siblings or among parents. They all are on the same plane. A person in a higher class of priority may designate another person on the surrogate list to be a surrogate, provided there is no objection. So for example, you could have the spouse indicating that they want a sibling to make the healthcare decision, and as long as an adult son or daughter does not object, that would be fine. Or a parent has to not object, then that would be fine. You just have to make sure that there's no objection by a person in a higher class. There are some restrictions on who may serve as surrogate. I just got a question about this recently. Employees of a hospital, nursing home, or hospice cannot serve as a surrogate decision maker unless that person is related to the patient by blood or there is a pre-existing relationship. If the physician becomes surrogate because there's a pre-existing relationship, then the physician can no longer be the attending physician. A court also can designate someone from the surrogate list to serve as a surrogate without considering the order of priority. So when there are disputes among family members and they can't all agree, the court can make that determination. And the court is not limited to the order of priority. If there is no healthcare agent or surrogate, then the hospital must identify, to the extent reasonably possible, and then document the patient's wishes and preferences about pending healthcare decisions. The hospital can then make decisions on behalf of the patient, as we'll talk about in the next few slides. We're moving to now talk about the healthcare decision. And the reason that we're going to talk specifically about the type of healthcare decision is that sometimes it affects which laws apply. So with respect to a healthcare agent, the scope of authority of a healthcare agent is that the agent can make, as we talked about before, any and all decisions that the patient can make. And it's subject only to any express limitations in the healthcare proxy and any other instructions like a living will or even orally that the patient may have given to their healthcare agent. It should be mentioned that a healthcare agent's decision-making authority does not commence until the patient's attending physician determines that the patient lacks capacity. So if you have signed a healthcare proxy to protect yourself now, your healthcare agent has no authority to make decisions for you while you're still functioning and able to speak for yourself. It's only when you lose that capacity to speak for yourself and that's determined by your attending physician that you cannot make healthcare decisions, that's the trigger that allows your healthcare agent to make decisions on your behalf. The decision-making standard that applies to healthcare agents are, first, consistent with the patient's wishes, including his or her religious and moral beliefs. And as we talked about a moment ago, a living will can provide evidence of the patient's wishes. Or if the patient's wishes are not known, then the agent must make decisions consistent with the patient's best interests. Now, the healthcare proxy law has a provision that still provides and says that for decisions regarding artificial nutrition and hydration, a healthcare agent can only make those types of decisions if the agent has reasonable knowledge of the patient's wishes, or with some due diligence, they can obtain that knowledge of the patient's wishes. If the patient has no healthcare agent, but the patient has a living will, then what? Healthcare providers may honor the prior decisions made by a patient concerning life-sustaining treatment that are expressed in a living will without seeking the consent of a surrogate. This is a provision of the Family Healthcare Decisions Law because, again, it's the patient who has the right to control his or her destiny. If there's going to be reliance on a living will in such circumstance, then the living will should be sufficiently specific to meet that clear and convincing evidence standard that this is what their wishes are. Prior to implementing a decision to withdraw or withhold life-sustaining treatment, the law does require that the attending physician make reasonable attempts to notify the surrogate of this happening, and if unable to notify the surrogate, then the physician must document the efforts that were made. And the physician must also document the patient's prior decision in the medical record. What if the patient only orally expressed their treatment preferences while in the hospital? Well, if the patient does make a prior decision to forego life-sustaining treatment, that too may be honored if it's expressed during hospitalization in the presence of 2 adult witnesses, at least one of whom is a health or social services practitioner that is affiliated with the hospital or nursing home. So that in that situation, the classic example is a patient who is in the hospital who has an advanced condition, advanced medical illness, where the progression of their illness is likely that they may experience cardiac or respiratory arrest. They want to have a DNR order issued, but they may not be ready at that moment in time to have the DNR, but they are considering it, and they're saying, if the following things happen, then I want you to make me a DNR. If that happens in the presence of the doctor and another adult witness, that can be documented and then followed. Again, the physician must comply with the notice and documentation requirements we spoke about in the last slide. Let's talk about the decision-making standards for a surrogate. A surrogate can make any decision the patient could have made in accordance with the patient's wishes, first and foremost, including his or her religious and moral beliefs, right? So again, surrogate must make decisions consistent with the patient's wishes. And if the patient's wishes are unknown, then the surrogate can act in the patient's best interests. There are additional standards that apply for decisions to withdraw or withhold life-sustaining treatment, and we'll talk about those. This is a slide on slide 34 that covers what is the best interest standard. What does that mean? And even though this comes from the surrogate, from the Family Healthcare Decisions Act, there is similar language that applies to guardians when they're making major medical decisions, as well as healthcare agents under the healthcare proxy law. So the best interests standard requires consideration of the dignity and uniqueness of every person, the possibility and extent of preserving the patient's life, the preservation, improvement, or restoration of the patient's health or functioning, the relief of the patient's suffering, any medical conditions, and such other concerns and values as a reasonable person in the patient's circumstances would wish to consider. With respect to decisions concerning life-sustaining treatment, there are some very specific criteria that must be met, and that's on slide 35. In that, if there's going to be a decision about the withholding or withdrawal of life-sustaining treatment, and DNR is considered by definition life-sustaining treatment, the patient must meet one of these two standards. The first is that treatment would be an extraordinary burden to the patient, and the attending physician, with the concurrence of an independent physician, determine that the patient either has an illness or injury that can be expected to cause death within 6 months, or that the patient is permanently unconscious. Notice I didn't say persistent vegetative state. The statute says permanently unconscious. So that's standard one. Standard two, the provision of treatment would involve such pain, suffering, or other burden that it would be inhumane or extraordinarily burdensome, and the patient has an irreversible or incurable condition as determined by two physicians. So that's the standard that must be complied with when making a decision, when a surrogate is making a decision to withdraw or withhold life-sustaining treatment. Prior to implementing a surrogate's decision regarding the withdrawal or withholding of life-sustaining treatment, a health or social services practitioner must confirm the incapacity determination. Again, we always want to give the patient one last opportunity to speak for him or herself. Let's talk about a healthcare provider's obligations. A physician and hospital must comply with the healthcare decisions made by the healthcare agent and surrogate in good faith, to the same extent as if such decisions had been made by the patient, subject to any limitations in the healthcare proxy or other advance directive, or if the patient objects. What this means is that essentially you must follow the decisions made by the surrogate or the decision made by the healthcare agent. But if you're provided with a document, such as a living will, or perhaps in the healthcare proxy itself, that has an instruction specifically contrary to what the decision maker is now telling you to do, what the healthcare agent or surrogate is telling you to do, that's a reason to stop and say, we have an issue here. because remember, the agent or the surrogate is required to make decisions consistent with the wishes of the patient. So they can't just override them on their own. And that would be a basis for either the physician or hospital to seek further clarification and not simply follow that direction of the decision maker. And if a patient objects, that's another reason that you have to stop and we would need a court order. So if a patient objects to a decision made by a healthcare agent or surrogate, notwithstanding the fact that they have been determined to lack capacity, we still need to go get a court order. And the reason for that is that both the Healthcare Proxy Law and the Family Healthcare Decisions Act have a statutory provision that says if the patient objects to the treatment decision, even after they're determined not to have capacity, we want the court to make the ultimate determination as to whether or not that patient has capacity. And so that's a situation where we must go get a court order. And we've done this many times, where you have a patient who, I'll give you a classic example, a patient who was psychotic, didn't believe that the mass in the belly was perhaps cancerous or was a mass, and thought it was some evil person who put the snakes in their belly. Even though that person is saying, no, I don't want the surgery, and their surrogate decision maker is saying, yes, let's save this person's life and do the surgery, we still have to go get a court order. And that's because that's what the law requires. The only exception is if you have already a determination by a court that the patient is not competent to make medical decisions. That would be the only time when we would not have to go get a court order, and the simple reason is because such a court order was already granted. Let's talk about court proceedings. An application to override an incapacitated patient's objection to treatment is generally brought as a special proceeding before the Supreme Court, or it can be brought to another court of competent jurisdiction. Right now in New York City and the surrounding area, the Supreme Courts, but upstate there might be other courts that are of competent jurisdiction to handle this type of proceeding. Special proceedings are fast-tracked proceedings. But at minimum, the patient must be given due process, which requires notice of the proceeding and an opportunity to be heard. In truly emergent cases, and we have done this for Bronx, Lebanon, we have been able to get a hearing perhaps the same day. It's very, very rare, and it is not something that we do lightly, but generally speaking, given the nature of the medical exigencies, the court must make accommodations. At minimum, the patient always must receive notice of the proceeding and an opportunity to be heard. In most cases, that means a set of legal papers that are prepared, that are submitted to the court, that the patient receives a copy of, and then the hearing is scheduled several days later. And there's an actual hearing, typically at the hospital. If it's medical treatment, it's at the hospital. Psychiatric treatment, there are certain days in the Bronx, it's on Wednesdays. These hearings are held Wednesdays. Not in accordance with the laws we've been talking about now, because those are a different set of laws, but that just gives you an idea of the types of court proceedings that we do. Court proceedings, as I said a moment ago, can be expedited and streamlined to meet the medical exigencies of the patient's condition. In the case where it was the same day, it was a person who was in labor, and it was, that person was declining certain treatment for their baby that was expected to be needed at the time of birth. Parent can decline for themselves. That they certainly have the right to do. We can't force that patient to have treatment. But with respect to the baby, a parent cannot deprive an infant or any minor of necessary medical care that's going to sustain that person's life. So the court hearing can be held at the bedside, and physician testimony is always required to establish both the lack of capacity as well as the medical necessity of treatment and the risks and benefits of treatment. And it depends on what type of treatment is being sought, because you have to have a physician who is qualified to speak to that area. It might be a psychiatrist who is testifying as to capacity, but you might need the surgeon if it's a certain type of surgery, or a pulmonologist, again, depending on the situation. What if there's an objection by a physician or the healthcare practitioner? An individual attending physician or healthcare provider, if they have an objection to the decision of a healthcare agent or surrogate, they must transfer the patient to a willing provider or refer the matter to the ethics committee. These types of objections can be raised if it's based upon conscience or religious objections. But again, obviously providers and physicians cannot abandon the patient, so they must continue to provide care and look to transition the patient to a willing provider. If the objection relates to a surrogate's decision to withdraw or withhold artificial nutrition or hydration, then the surrogate's decision will not be implemented until the ethics committee or a court determines that it meets the legal standards. This is a specific exception that is provided in the Family Healthcare Decisions Act that applies just to matters of withholding or withdrawing artificial nutrition or hydration. There are special requirements now in the laws that were added at the same time that the Family Healthcare Decisions Act was promulgated in 2010. And this law requires that if a healthcare agent or a surrogate directs the provision of life-sustaining treatment, right? So now you're going to provide, they're directing that you provide life-sustaining treatment, the denial of which would be likely to result in the patient's death. The hospital or individual healthcare provider, practitioner that does not wish to provide such treatment must nonetheless comply with the agent's decision pending either transfer of the patient to a willing provider or a court order. So this is a situation where the agent or surrogate is telling you that you must provide all life-sustaining treatment measures, and by that it would be, CPR, pressors, artificial nutrition and hydration, antibiotics, whatever it may be. If those measures are necessary to sustain the patient's life, and if you didn't provide those measures, it would be likely to result in the patient's death, then this provision of the law requires that you must comply with that direction pending either transfer to another doctor or hospital willing to do so, or getting a court order. But I want to mention that this has to do with an objection raised by the practitioner in providing that treatment. This provision does not apply when it's the patient who said, I don't want to have that treatment. So this particular slide does not apply when a healthcare agent is directing CPR and there's a living will or instructions in the proxy that say, I want to be a DNR in these circumstances, and now it's the healthcare agent trying to override the patient. The healthcare agent cannot do that, as we talked about before. And that is not what this slide on 42 deals with a discrepancy or a dispute between the doctor and the healthcare decision maker, not the dispute between the patient, him or herself, and the healthcare decision maker. Life-sustaining treatment on this slide as well is defined as any medical treatment or procedure without which the patient will die within a relatively short time as determined by the attending physician to a reasonable degree of medical certainty. So you can see just how broad that term is. So let's talk for a few minutes about a patient without capacity and someone who has no healthcare agent or surrogate. Under the Family Healthcare Decisions Act, a decision to withhold or withdraw life-sustaining treatment may be made for that truly isolated patient who has no healthcare agent or surrogate that is available or willing to serve. You have no way of reaching them, no contact information. You make diligent efforts to reach family, but they live in another country and you have absolutely no way of obtaining the information. And you have made some diligent attempts. But in that situation where you have no healthcare agent and surrogate, then decisions can be made for that patient by a court in accordance with the same decision-making standards that apply to a surrogate. And if you don't go to court, a decision about life-sustaining treatment can be made by an attending physician with the independent concurrence of a second physician, provided that both doctors determine that life-sustaining treatment offers the patient no medical benefit because death is imminent, even if the treatment is provided, and the provision of such treatment would violate accepted medical standards. That's a very high bar. That's a very, that standard requires that it's much more than futility. This is not a question of medical futility, meaning that the patient's condition is not going to change, that even if we provide treatment, the patient is still going to be suffering from whatever their underlying medical condition is. That's not what this means. What this means is that even if you provide the treatment, not only is it going to be futile, but the patient is actively in the process of dying. We believe that death is imminent. No one has a crystal ball. I understand that the doctor cannot predict that the patient's going to die today or tomorrow or in 2 weeks, but there does have to be a determination that even if we provide this treatment, the patient has started on that path of dying, and there's nothing that we're going to do that's going to change that. If that is where the patient is, they're in multi-organ system failure, and even with pressors and blood transfusions or whatever, it's not changing the decline of this patient. They're still declining. That's an appropriate circumstance for 2 doctors, the attending physician and a second doctor chosen by the hospital, to decide that there should be a withholding or withdrawal of life-sustaining treatment. And it might just be a DNR. It doesn't have to, it depends, whatever they choose to do. And that's appropriate for that patient. Now, the law was changed a couple of years ago with respect to hospice care for that same isolated patient. So if you have a situation where you, again, have an isolated patient, no healthcare agent, no surrogate, decisions about hospice care, whether to enroll the patient in hospice and to determine the hospice plan of care, and remember, hospice might include DNR, it might include other decisions to withdraw or withhold life-sustaining treatment. Those decisions can be made for hospice under the same standards that apply to a surrogate. So here's a situation where 2 doctors, the patient's attending physician, with the concurrence of another physician selected by the hospital, may enroll a patient in hospice care and determine the plan of care under those same standards that apply to a surrogate, which were, as we talked about a moment ago, much looser than the ones that apply, where death is imminent. So let's spend just a few moments on DNR provisions. Consent for a DNR may be given by the patient, healthcare agent, or surrogate decision maker, a court, or 2 physicians pursuant to the decision-making standards for life-sustaining treatment under the Family Healthcare Decisions Act. And if the patient is developmentally disabled, we have to follow 1750B. So under 1750B, there has to be a confirmation of the patient's incapacity. 2 physicians have to determine that the patient meets certain criteria that life-sustaining treatment would impose an extraordinary burden on the patient. And notice must be given by the attending physician to certain persons at least 48 hours before following the decision. So on slide 48, there's a description of the medical criteria. Patient has to have a terminal condition. In this statute, it's defined as death within 1 year. be permanently unconscious, or have an irreversible medical condition other than their developmental disability or intellectual disability, which requires life-sustaining treatment and will continue indefinitely. There is an additional requirement that there be a determination that life-sustaining treatment would impose an extraordinary burden on the patient in consideration of their medical condition, again, other than their mental retardation or developmental disability, and the expected outcome of life-sustaining treatment. With respect to artificial nutrition and hydration, if that is the decision being made, then two physicians must also determine, in addition, that there is no reasonable hope of maintaining life, or that the artificially provided nutrition and hydration poses an extraordinary burden on the patient. If an objection is made, that stops the whole thing. So objections to a decision may be made by the patient, by a parent or sibling who has maintained substantial contact with the patient, an attending physician, any healthcare practitioner providing services to the patient. If the patient resided in a group home or other facility that's licensed or operated by OPWDD, then the CEO of that facility or director of that facility and mental hygiene legal service must receive notice. And if the person was simply living in the community with mom or dad, the commissioner of OPWDD or his or her designee. As I said a moment ago, an objection suspends the healthcare decision pending a court order. There has to be judicial review, except if the suspension is going to, if the suspension will, in the reasonable medical judgment of the physician, be likely to result in the death of the person. So with respect to interinstitutional transfers, when you have a DNR, if the patient goes from a hospital to a skilled nursing facility, right, that's an interinstitutional transfer. So with respect to a DNR or MOLST or any other order to withhold or withdraw life-sustaining treatment, the existing plan should remain in effect until the patient's doctor sees the patient and then either issues another order, to continue the plan, or cancels the order because it's no longer appropriate. So when a patient goes from a hospital to a nursing home with a DNR, the DNR remains in effect at the nursing home pending the doctor's examination of that patient and either continuation or cancellation because it's no longer appropriate. And same when the patient comes back from a nursing home to a hospital. If the patient comes to the hospital with a DNR that was issued in a nursing home, the DNR remains in effect pending the physician's examination and reissuance of the DNR. There is an obligation to honor the MOLST form and non-hospital DNR. The statute expressly provides that emergency medical service personnel and hospital emergency department personnel who are provided with a MOLST or a non-hospital DNR, or who identify the standard bracelet, the non-hospital DNR bracelet on the patient's body, they must comply with the terms of that order unless they believe in good faith that consent to the order has been revoked or the order was canceled, or if there are family members or other persons on the scene that are objecting to the order and there appears to be a physical confrontation likely. Of course, we don't want to have any kind of physical confrontation, so EMS would provide CPR in that instance. And hospital emergency department physicians also may direct that a DNR be disregarded because of significant and exceptional medical circumstances that warrant disregarding the order. I would say that's probably fairly rare. Objections, immunity, and liability. There are conscience objections that can be raised by hospitals and individual healthcare practitioners, and there's a protection for hospitals and individual healthcare practitioners. There's a protection from liability for acting reasonably and in good faith. I will say, though, that the statutes do now provide liability for healthcare costs for any hospital or nursing home or hospice or attending physician that refuses to honor the healthcare decision made by a surrogate, except in the event that there's a conscience objection and there's a pending ethics committee review, and or if there's a dispute on the surrogate list, or with the healthcare, or if a healthcare provider prevails in litigation. So, whenever we have an issue where there is a dispute, send it to the ethics committee, involve administration, take appropriate measures, and that should protect you. If you're acting in good faith, that should protect you from liability. We're coming to the close of our session. We still have a few more slides on the ethics committee and the functions of an ethics committee. You have these slides available, but we can quickly just mention that an ethics committee must be convened to consider and respond to any healthcare matter presented to it by a person connected with the case, including providing advice on ethical aspects of treatment, making recommendations about treatment, resolving disputes, and approving certain decisions regarding life-sustaining treatment. We talked earlier about when a physician objects to the withholding or withdrawing of life-sustaining treatment, if the attending physician is objecting to that decision, then the ethics committee must make a decision that it meets the criteria. Generally speaking, the ethics committee recommendations are just that, are recommendations and advice. They are not binding. They're only binding in the instance I just mentioned, and if the decision concerns an emancipated minor's decision about life-sustaining treatment. That's the only other time when an ethics committee determination is binding. There are committee procedures which are required. Prompt notification of a pending case must be given to certain individuals, to the patient if able to comprehend, to the surrogate, to other persons on the surrogate list that are directly involved in a dispute, to a parent or guardian, an attending physician, a hospital administrator, and other persons on the committee. And the committee must permit persons who are connected with the case to present their views to the committee. A copy of the committee's response must be provided to interested parties. We mentioned who they are a moment ago. Decisions related to the withdrawal or withholding of life-sustaining treatment. In those situations, treatment must not be withdrawn or withheld until all of the interested parties have been notified. And for purposes of HIPAA and privacy concerns, committee members may access patient records to perform their functions. So that brings us to the end of our presentation. Thank you, everyone, and this concludes our webinar.